One of the questions that's often asked is, what is the legal basis for how you go about managing fatigue within an organisation? And while it may seem like a simple and straightforward question, it isn't always. For example, we've been involved with inquiries following events, for example, in bushfires or emergency services where people have been required to work incredibly long hours, and as inevitably is the case, there are fatigue-related errors. One of the difficulties is, with the wisdom of hindsight, everybody can see that that was an inevitable consequence. If somebody was going to work long hours, then a certain number of times people are going to make mistakes and things will go wrong. The challenge, however, in many organisations such as emergency, healthcare, defence and other industries where the management of fatigue also involves the potential withdrawal of services, we are faced with a very vexing and thorny question. How do I justify legally my decision to continue to work or to not continue to work? That's not a very simple question to answer, but what we're going to talk about in this particular section of the course is a legally and scientifically defensible framework for how an organisation sets up and negotiates the structure for what constitutes the basis of their fatigue management program. As you'll see from the slide, the phrase here seems a bit convoluted, but it's actually worth thinking a little about. That is, if you read what the slide says, it says the risk of working fatigued must be less than the risks associated with not working while fatigued. Sometimes that has been put into very simple terms by saying, how many hours is it reasonable for a doctor to work? We did some research on this a couple of years ago and we asked people what was a reasonable amount of time for a doctor to work, and most people thought 12 or 16 hours was about the reasonable upper limit. The difficulty in Australia is that doctors typically work 24 to 36 hours at least a couple of times a week if they're hospital-based doctors. If we were to limit doctors' working hours to 12 to 16 hours, then we would need thousands of more doctors around Australia, and we don't have them. We don't have the resources, and the community at the current state is not prepared to pay for them. So we're left with the issue that if we are to limit working hours in ambulance officers or doctors, firemen, and then they are unable to provide the community a service, what are the risks associated with that? Now, when we went back to those communities and said, well, if we limit doctors' working hours to 12 to 16 hours, and the consequence of that is that you can either have a tired doctor or no doctor at all, which would you prefer? People said quite reasonably, oh, a tired doctor will be fine, thank you. In many occupations, not only do we have to assess the risks associated with continuing to work in terms of the fatigue associated with that, but sometimes we have to assess the risks associated with not continuing to work. And that creates a very vexing legal problem for organisations. So while the wording here is a little convoluted, think about it. The risk of working fatigued must be less than the risks associated with not working while fatigued. And in order to understand that, you'll have to look at it from a risk-based perspective. That is, what is the likelihood of a fatigue-related error and the consequence versus the likelihood and consequence of an error or an adverse outcome associated with not providing that service. And that risk calculus can be quite complicated. But while we would advocate that as a working definition that organisations can use to underpin how they make decisions about how many hours people will work, whether they will allow shifts to be extended, at what point people choose to stop working, or at what point the organisation insists that they stop working, there needs to be a number of things in place for that to be a credible framework. And the first of these is that you need a defensible process for assessing the risk. That is, you need to be able to defend that your assessment of the likelihood and consequence of either a fatigue-related error or an adverse outcome associated with failing to continue to work must be in place. You need credible risk controls in the event that you do continue to allow somebody to work where you think the risks of not working outweigh the risks of working fatigued. And similarly, you need a transparent audit review process that enables you to determine whether what you are doing is actually working or not. One of the big problems with fatigue is that the error rates associated with fatigue are quite low. In the laboratory, you may go from a 1% error rate to a 3% error rate when you're fatigued. When you're driving a car, your risk of having an accident fatigue may go from 1 in 7,000 trips to 5 in 7,000 trips. The overwhelming likelihood is that you still won't have an accident or won't make an error. So part of the challenge is, how do you work out when you're trading low frequency or low likelihood, high consequence events against high frequency but potentially low consequence events, and how do you weigh up that risk calculation becomes a very complex organisational challenge. Part of the process here is that you need to be able to review and you need to be able to determine whether you're making those decisions correctly or not before the accident happens.